Good morning, everyone. We'll call the February 2nd, 2010 meeting of Jackson City Council to order, and if you would, please rise for the invocation and pledge given by Councilman Buchanan.
Let us pray. This morning, our gracious Heavenly Father, we petition our throne, first of all, thanking you for allowing us to see another day. Thank you for the many blessings that you have so richly bestowed upon us. We pray and ask, Father, that you keep us in your keeping and protect us from all hurt, harm, and danger. Forgive us of our many sins that we have transgressed against thee. We pray, Father, that you would continue to hold your ever-loving arms of protection around the country of Haiti as a worldwide effort to bring relief. Father, we ask that you grant us strength, wisdom, courage, knowledge, and conviction as a board to benefit the city of Jackson through our deliberations and through our voting. Go with us and stand by us. In Jesus' name we pray. Amen. Amen. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Nate, I think you can show all council members present, and have the approval of the minutes of January the 5th, 2010. I think those minutes have been distributed. Is there any corrections or additions to those minutes? If there's no objection, then we'll accept those minutes as submitted. We do have one proclamation this morning, and I'll come down. Let me ask Dwayne Cherry and his staff of Mission Convalescent Home to come up to the podium, if you would. Have all of you here this morning. We received a great honor, and that's one reason for the proclamation this morning. I'm going to read the proclamation, make it a part of the minutes of this meeting, and then I'll ask Mr. Cherry to make a few comments on behalf of the Mission Convalescent Home. Whereas realizing the need for a quality nursing home facility in Jackson, Tennessee, 27 ministers took a leap of faith and formed the Mission Convalescent Home in 1961 with $240. Whereas Reverend Udell Lewis served as the first Mission Convalescent Home Director at its present location at 118 Glass Street. And whereas the February 2010 edition of the U.S. News and World Report ranked the Mission Convalescent Home in Jackson among the top nursing facilities in the United States. And whereas the magazine named the Mission Convalescent Home the only nursing home in Tennessee to be included in its list of 173 of the nation's best. And whereas the U.S. News and World Report based their findings on health inspections and performance within a wide range of quality measures. And whereas the City of Jackson salutes Mission Convalescent Home leadership and staff for providing this vital service to Jackson's elderly residents. Now, therefore, I, Jerry Gist, Mayor of the City of Jackson, Tennessee, do hereby proclaim Tuesday, February the 2nd, 2010, as Mission Convalescent Home Day, and witness whereof, I hereunto set my hand and cause it sealed, the City of Jackson, to be affixed the second day of February 2010. And Dwayne, on behalf of the council, people of this city, we congratulate you and thank you for what you all do.
Well, first, we'd like to thank Mayor Guest and the City Council, and particularly our City Councilman in District 4, Councilman Harvey Buchanan, who just as elated and excited as everyone up here. From the Board of Directors, we have a couple of them here, Attorney Nathan Pride and Michael Cherry. From our staff on down, department heads, James Cherry, Tawana Walker, Mary Lofton, and who's ever else present. And for this wonderful, wonderful staff we have standing around us. It's been a hard journey, but it's been a journey well deserved. We've never had a day before, so I guess when we have our survey this year, we're gonna have to be perfect again. And then next year, we get another day. But for this staff, you know, when you look at life, people often look at life and they judge you by what your occupation is or what your career is or what your job is. You know, although our job is at Mission Convalescent Home, what we really are good, dedicated, loving servants who just try to do a service every day for people that can't help themselves. And you know, we have, I don't have many rules at Mission, but 2 rules I have is, number 1, treat your co-workers like you love yourself. And number 2, treat our patients more than you love yourself. And so those are the 2 rules that we go by, and we'd like to thank the city once again for this wonderful honor. And I'd like to just thank my staff for coming out, and thank you. We're going back to work now.
Okay, next is the invitation for public comment, and I'll ask if there's anyone present who would like to be heard on any item under new business. And if there is, I would invite you up at this time to indicate your interest. Anyone here? Yes. Come on up, sir. Would you come to the front there and just please introduce yourself, if you would?
My name is Richard Archie. I want to ask a couple of questions of the council, if I might, with regard to the passage of the municipal code. As I understand, the draft supplied by the MTAS either has to be voted in or voted out. There is evidently no discussion about the articles in the draft itself. Having painstakingly gone through several pages because it's very long, I find several issues contained within that are in contradiction to state code. And I'm concerned that there is no discussion on the part of the council as to whether those issues are legal or not. And so I would ask what the deal is with the MTAS. They're supposed to be an advisory service. They're taxpayer funded, and they write these and send them down, but yet our council, if I read the city charter correctly, says that they're responsible. So I'm concerned that the MTAS can blanket put forward a municipal code, and yet our city council doesn't have an opportunity to look at that and dissect it on issues. So I'm confused. Can somebody answer that for me?
Okay. Mr. Cobb, can you kind of straighten that out, if you would?
We'll see.
Okay.
The process that MTAS is doing is called codification or organization of the existing ordinances. And what they've done is taken the body of ordinances that are currently in force and tried to organize them, or in this case, reorganize them into a form that is easy to look at, review, analyze for the public. And during that process, they've made some revisions, and it's my opinion that this council, if it passes this codification, adopts the language in the codification as the new body of you don't call them laws, you call them ordinances, but it's That's what it is. Now, it's my understanding that each of you has had available, and many of you have gone through line by line each of the ordinance and the codification. I know that because I've had several calls from several of you. So it's my opinion that if this body votes to adopt the codification, that is the official code in that form. I don't know if that answers his question, and I'll be glad to answer his question or any of the council's.
Go ahead.
I think Councilman Wallace was going to ask something, maybe not.
The only comment I have is that there are some things, Mr. Archie, I agree with you, there are some things in the code that are no longer correct. I think we realize that, and we're in the process of correcting those. But the codification we're approving today, or is on the ordinance that we're on the agenda today to approve, is what we actually have on the books right now, whether it's right or wrong. There's some things on there that are wrong, I think, that are in the current code. At the next meeting, I intend to bring forward a couple of new ordinances to correct the things that are incorrect in the code. But what we're approving today is just the code that we've got on the books, even though some of it is the law, and some of those is incorrect.
If I might suggest the language, there are some things that are in the existing city ordinances that conflict with state law. If our ordinances conflict with state law, then the state law controls. Just as if state law conflicts with the Constitution controls. It's the hierarchy.
Not necessarily, because there are certain instances in which the codification says if your city ordinance was passed before such and such date, then it's grandfathered in or it's not preempted. And that's my question. By passing this codifying this process, are we taking anything that was passed, say pre-1986 and before, are we taking it from the grandfather state and placing it into the preemptive status with state law?
My opinion, with 15 seconds to think about it, is that the codification is the organization, and that if the codification refers to an ordinance passed in 1982, for example, then it was the 1982 action that is the origination of that action.
Then let me take it one step further, if I may.
But I'd like to have somebody whose name begins with Judge to agree with me first before I feel real comfortable. I think that's the case.
Well, there are several instances in which the ordinances were modified.
Right.
And that came after a date and time on which the preemption went into effect. If an ordinance is modified after the preemptive date, does that, again, take it out of its grandfather status and place it into a status that it's preempted?
The ability to receive grandfather status is something that state law controls. And I don't know if it's the same for every ordinance or if it is different for particular ordinances. I really would feel more comfortable answering it ordinance by ordinance and then looking at what the legislature adopted, the language that they use for grandfather, because it's not always the same. But I think as a general rule, if the idea is for cities who have adopted a practice and procedure and the state law changes, we'll allow those who acted before we did to continue that or to continue for a period of time unless it involves issues like public health, safety, things like that, is a general practice, Councilman.
So since we're going through the codification process and we've already found several innumerable conflicts between what's there now and what's on the state law books, would now not be the right time to clean it up and streamline this process instead of having to go back through 2 readings of an ordinance to, in effect, change the statute?
Well, you
If I might comment on that, that's what we paid MTS to do. They came back with 16 changes where our ordinances conflicted with state law and changed it. I mean, you're shaking your head no, but that's what we paid.
Well, I understand that, Mr. LaFoon, but we still have sections that are still in conflict.
Well, I have met with, most recently, Councilman Wallace, and we've got during Bray, and to my knowledge, satisfied all of their questions.
It was my understanding that they were under the impression, though, that we couldn't amend the codification process now, that it would have to come subsequent. And that's my question today, and it has always been my question. Can we modify the codification section now?
Defer to Lewis on that.
May I ask a question? I think part of this process was also, there's a date that we're limited to, and is that June 29th? June, late?
Otherwise, we have to start all over and pay them another $10,000.
Okay, but June is several months away. So the question that Councilman Ellis is referring to means that if we make a modification today, we still have this approval, then next month's approval, which is still prior to June. Is that correct?
This is our second approval.
Mr. Chairman,
Let's just say that, no, if we make a modification, it'll have to go through a second approval. Is that
Mr.
correct?
Chairman.
Is that correct?
I'm not sure.
Councilman Buchanan.
with respect to modifications and adopting of the ordinance, we are on second reading. You have to have a public hearing for the modifications, which would start the process all over. Is that not correct?
In passing an ordinance, there can be amendments to the ordinance during the second reading. What we're doing is a codification. And so I'm not sure, and I have not researched whether a codification is the same procedure as an ordinance, or since it's more or less an organization, categorization of the existing ordinances, whether it's different. I don't know. I think I think it probably could be amended, but I would, I'm just not sure, Councilman. I'm just not sure. I'd like to have a few minutes to think about that and research that. I know we got in that issue earlier, late last year, about the amendment process. I do know that an ordinance can be amended in their second reading.
I have a question, if I may. How many times have we tabled it's been tabled once?
I believe. I don't know. Mayor, we have a question, procedural question.
You have a question?
No, Councilman.
No, my
Councilman,
question
I'm
was, how
sorry.
many
Go
times-
ahead, Councilman.
How many times has this matter been tabled?
Councilman Wallace, how many times have we tabled this? this
I think just once, but in the process of tabling it, I didn't realize we had till June to do it. Had I known that, I probably would have pushed to get all the corrections in there, because MTS did make some corrections to it. There's 2 other corrections that I know of that need to be made that haven't been. I've got no problem with tabling it, getting those corrections in the current codification, and approving it next month.
I'd like to make that motion if I could.
I'll second that.
Council mind waiting till we get to that item on the agenda, then we'll address that. Right now, we're in public hearing on comments relative to that item, but we'll be happy to handle it once we get to that item.
My thoughts on the amendment process, and I've given that some thought since we did that in open court, if you will, is that I would feel more comfortable if the amendment was in writing, so that we all agreed on the exact language that we're considering, instead of having hey, I've got a great idea,
Right.
particularly on the second reading. And if I had to bet, I would say that this council on the second reading could make minor modifications to an ordinance, so long as it fit within the general parameters. What's concerning me is codification is the entire code, and to say we're going to consider the entire code, and then you can amend anything on one reading of the entire body of ordinances, causes me a little concern. I would not recommend doing it, although it might be sustainable.
One more question.
Councilman Udecker.
Part of the codification is also part of the charter, and we're also voting on that particular part as well. Is that correct?
No.
Okay, thank you. I appreciate
Only
that.
the legislature can amend our charter.
Okay. But it is part of the codification.
No. The charter is the charter, and this body has no ability to do anything other than request the legislature to amend the charter.
Okay, any other questions of council? Go ahead,
Are you saying to us, postponing it until the next meeting, tabling it until the next meeting, making those corrections that need to be made, and then bringing it up the next meeting is okay, or is not okay?
I would say there'd be 2 ways to do it. One would be to make written proposals for amendments, make sure that they're publicized and considered at the next meeting, or pass what we've got, which is the codification of the entire body, and then address if there's a sentence or a paragraph in one ordinance out of the thousands that we have, you could handle it by just simply amending that particular ordinance, which would then be fixed in the next codification. Either way would get you there.
What's the difference in us making these other changes and the changes that MTS has already made? Because they've made some changes to it, and we're gonna approve those. We approved those the first reading last time, second reading. I don't understand what the difference is then.
The difference to me is that if someone made an oral motion to change this body of ordinances without notice, and without it being in writing, that process is something that I don't think is recommended. It might be.
But I mean, if it's in writing for the next meeting, we'll be okay on that.
It needs to be writing and publicized. I think
Okay,
that'd be
well,
fine.
yeah, I think we can do that then, okay.
Mayor, if I may.
Sure. Go ahead.
If I may make a suggestion, I mean, we're talking about a process we're not even sure is we can do. So I think it would be beneficial for this body if we could have an opinion from you, Mr. Cobb, as to whether we can even do this.
Sure,
If we can
and I'll be
amend the
glad to get one.
codification process first, and then if we can, then any councilman who wishes to submit any final changes do so in writing. If not,
Hold my calls.
if not, then it's a moot point. We pass it next time and we go about the cleanup process.
Well, let me say this. I know this process works. If we pass the codification, any of it, all of it could be amended during the normal ordinance procedure at any time by this council or by any successive council. I know that works. The other is something that, the other is something I'll need to look at. If it was just a typical ordinance with very limited scope, I feel comfortable advising you, but if a codification of the entire body, I'm a little concerned.
So what you're saying, if the ordinance passed today on second reading, we can come back at any time with amendments?
Sure.
I think it would probably be in order to have all of those amendments ready at the next meeting, to where we can act on them at one time and put this issue behind us and move on. I think that's probably best for us to do. Any other questions? Okay, thank you, sir, for your comment. Anyone else would like to make any comment relative to new business? Yes.
Morning, Mayor Gibbs.
Morning.
Council
Morning.
members. I'm Jeff Rice, District 6. Again, I just want to comment on this municipal code review, and my concern is that if we're doing things that are changing the intent of law, that's very different than changing the verbiage or adding a index to the back of it. And I would just encourage you guys to, I'm pleased with the discussion that we've had this morning concerning this issue, and I hope that each of you have an opportunity to read through this and understand exactly what you're voting on and understand what the implications are for your constituents on any changes that affect the code. You know, when we bring an issue on the agenda, you know, we've got an issue today, for example, with the curfew. You know, we're going to have a lot of debate and discussion on that one issue. We're changing multiple things in here in this code, and I think it's worthy of enough debate and discussion. May I comment on the curfew issue?
Sure, absolutely.
I think I understand what the intent that we're trying to do here. And you can do a Google search and find all kinds of studies that show that a curfew doesn't always produce the desired result. And you know, just as with this municipal code review, I hope that we have debate on what the unintended consequences are of such actions, and that we look at actual studies rather than someone's opinion. And appreciate the opportunity.
Thank you. Scott?
Mr. McClune has been the one that has been primarily processing this. We did have a meeting, and in that meeting, MTAS said that what they had done was take our ordinances, take our new ordinances, and then the changes that are in the ordinances are all changes dictated by changes in state law, and each of those changes, there is a reference or a footnote to the state law that overrode or superseded. So it's not that the MTAS rewrote our code, it is that they organized our code, incorporating changes that this body and its predecessors made, and then the changes the legislature made, and take them and organize them.
Okay, I think you just answered my question. So if there's a footnote to an ordinance, that's MTAS saying that that ordinance has been preempted.
I don't think I'm not sure that's exactly the style. I think they refer to like TCA 101 or
But
something.
but it'll say,
There's a reference point.
there's a reference point, and that's my question, is if there's a reference point, then is that MTS saying that that code has been overridden by state law?
That's my understanding. And the specific ones we've looked at, there was a reference to a state statute
Correct.
where you could trace the origins of the language. Is that,
Yeah, I think that the two changes we're looking at, there are references, there can be references for state law that
Right.
shows that they've been, so I don't think that's a problem for us.
but it's not that MTS got back in the room and said, this looks like a bad law, we'll change it. They didn't do that. They've incorporated what this body or its predecessors or the legislature's done.
Okay.
All right, do we have a motion on the floor?
No, not yet,
We're still in public comment.
preferably. Yes,
Curfew when it comes up.
sure, go ahead. You can go ahead right now. You'll identify yourself, please, for the council.
My name is Sheila Godwin, and I'm here to speak in regard to the curfew ordinance that's coming up for the first reading. As of Sunday, the 31st of January, I guess I've kind of been in the dark. I haven't been to any meetings, so I didn't know anything about the curfew. When I ran for mayor, I supported curfew, and I still support curfew. But I don't have all the language. I overheard the language over a radio talk show, and according to the language, I wasn't very satisfied with that. Of course, it's not about me, it's about the community, it's about the children. We do need to keep children in, but the way we do about it, I'm very concerned. I'm concerned for the fact that I do know that we have people out underage and overage, and I'm concerned about how you're going to approach this physically and individually. I'm concerned about the fact, the language about, I think I heard on the radio, I don't have it before me, about the children would be turned over to a parent, and they would have to be out with a parent about a stool, either it had to be related to a stool function. Again, I don't have all the language before me, but from what I heard, I think it should be a little bit more precise than a parent. Sometimes kids are out with their older sister or brother, and I understand you may not think that's right, but the parent may think that's all right for them to be in a public place with their older sister or brother or someone in the household. Again, I'm not telling you what to do. I do support a curfew, but I'm very concerned about the language. Also, I'd like to ask the question, did you have a public meeting on this other than here? I hadn't heard anything about a public meeting to the community about a curfew. If not, I've heard previously coming up to this platform that's good to bring issues before the public. And sometimes we don't bring issues before the public, and we assume that people know because we put them in the paper. Everybody don't read the newspaper. Everybody not on the internet. So again, my concern as a community person is that you bring it to the people. Now, I did hear wide support for it over the radio, but my concern is I do support a curfew, but I'm concerned with the language and how it's going to be done and the guidelines specific. Because, you know, once you go and pick up a child, the parent is contacted, the parent is responsible for that child, and I'm concerned that we don't put a lot of police out in issues, take them away from things that they should. A child should not be out, true, but I'm just concerned with the how we go about doing it. You know, I just don't want, not whether a black boy or white boy. I don't want just a lot of boys out, and girls too. I'm concerned about how you're going to approach this situation. So before you vote, and I want you to think about the language that you're going to use with this ordinance. Thank you.
Thank you, Ms. Cobb. Maybe we can answer some of your questions as we have our city attorney and Captain Corley, police advisor with the police department, explain the elements of the curfew. Anyone else who would like to be heard on any matter under new business?
Mayor, City Council.
Morning.
Good morning.
Morning. My name is Harold Carter. I serve as president of the Jackson-Madison County branch of the NAACP. We've had several calls concerning this particular ordinance, and I've talked with several of you about it. I think the intent, obviously, is a good intent, but I believe that if we would take it a little bit slower. Not that we shouldn't commit ourselves to crime reduction, because that's all important. But I think if we took the approach of perhaps if you adopt this ordinance to make it a sunset ordinance after 1 year, keeping the appropriate data that's needed to see how it works and how the community feels about it over a period of a year, I think we can look back and see whether it works or not, and whether or not we can go full force with it, or to make sure that we have all the bells and whistles that we need in order to make sure that everybody is pretty much set with it. But basically what I'm saying, a suggestion to you, if you adopt the ordinance, make it one that sunsets after a period of time, maybe a year, keeping all the appropriate data as to who, what, when, where, and how, and all of that. So we can take a snapshot look at what has happened, what has transpired, and where we need to tweak it, and how we could go forward in a way that is approval with the general community.
Mr. Carter, the council can rescind the ordinance at any time. However, one element of the ordinance indicates that the police chief is to come back to council after 6 months and give the council a briefing as to the productivity, lack of it, as far as this particular ordinance, how it's going. And I think once Captain Corley comes up and the city attorney has discussed how it will be implemented and the discretion within this ordinance, maybe that'll help answer some of your questions.
I think the appropriate data is important in terms of where the stops occurs and what circumstances and who's being stopped and et cetera, because I think then we can take a snapshot and look and see if there's some tweaking that we could do in order to help it to be more enforceable. Okay. Thank you.
Thank you, Mr. Carter. Anyone else like to speak on any item under new business? If not, then we'll close the section as far as public comment and move to our first readings. Item 7, number 1 under first readings, consideration of the juvenile curfew ordinance. And we have, I know we have our city attorney here. We have Captain Corley. Captain, you want to come on up, if you would, the legal advisor of the police department, and answer any questions from council that they may have in reference to this ordinance.
Good morning.
Good morning. I believe everyone has a copy of that ordinance. And I myself was not part of the initial meetings that were involved in discussing this. However, did play a part with the enforcement. As far as the enforcement of the ordinance, I can address those issues as far as how the police department will deal with juveniles that are affected. In section 105 of the ordinance.
Captain Corley, let me, sure. Dr. Lake, would you mind coming up, because I know you work with the committee, several different meetings, maybe between the two of you, we can get to where we need to be.
No.
Go ahead, Captain, I'm sorry.
That's fine. The ordinance as written will allow a police officer who has probable cause to believe that the minor that they may encounter, whether it be on a call or that they observe in a public place, between the hours of 11 p.m. and 6 a.m., I believe, for the age of 17, and 10 p.m. and 6 a.m. for the age of 16, the officer will be allowed to then ascertain the name, the age of the child, of the minor, and contact the parents at that point or guardian. And if we are able to contact the parent or guardian at that time, then the officer has some discretion as to the next step. Depending on the circumstances, the officer may be able just to cite the minor and send them on home. After they've contacted the parent, they could have the parent come to the location where the officer is, cite the minor in the presence of the parent, and let them go on home. Or if the minor lives in the city limits and the parent is not with the means to come retrieve the minor, then the officer has discretion to deliver the child back to the parent. If we're not able to communicate with the parent or guardian of the minor, and the minor is uncooperative, or the parent, if we do try to get a hold of them, is not cooperative in trying to retrieve the child or cooperate with law enforcement as far as transporting the child back to where they belong, then the officers will transport the child to Madison County Juvenile Detention under the premise of the welfare of the child being unsupervised under our neglect statutes under the state. So that's where an agreement, I believe, with Madison County Juvenile Court Services comes into play, where they will treat that just like any other juvenile that we bring in for the same.
Okay, Dr.
Mr. Chairman.
Go ahead. Okay.
I've heard you speak on what you would do if he's illegally out, he or she, the juvenile. But what if you stop one who's legally out with respect from employment and that person is stopped? What's the after effect of that?
That's where the officer has that discretion. When they make that first contact, we have to determine, is the ordinance being violated? If the juvenile or the minor is out legally by the draft or the way it's written because they are employed under the exceptions that are listed here, or they're involved in a school or religious function or with the parents, then that's where the contact stops because they haven't violated the ordinance.
Second question, under your section 104, with respect to exceptions.
Yes, sir.
Item number 3, when you say that juvenile is legally employed and he has a period of 45 minutes after work to go directly home without any stop or detour. Now, if his mother or parent told him to stop by the store or pick up something, bring home, he can't do it?
I believe with anything, there's some reasonableness that has to be applied.
Yeah.
If an officer stops a minor, and it's after this time period, say 1 o'clock a.m., and we ascertain the name and the age, and we ascertain that the minor is on his way home from work, and there's nothing else that would precipitate a reason for the officer to continue that stop because maybe they are doing something for their parent, then that's certainly okay. Again, the officer, if there's a possible violation, the officer's means is to contact the parent. If the parent says, yes, I asked them to stop and pick up milk on the way home, I don't think there's an issue where the officer's going to take that child into custody.
Would that be harassment?
Would it be harassment?
Yeah.
No, sir.
Wouldn't?
I don't understand the
A
question as
person
far as
coming home from
harassment.
work and he stopped somewhere else to pick up something that his parents has asked him to pick it up. Is that harassment?
No, sir. I think the issue here by the council approving this ordinance would say that this is an issue where we're trying to ascertain why the child is out, and if the child is out for a legitimate purpose, then that's where the stop ends.
As I spoke Thursday at pre-agenda with respect to your public relations on this juvenile curfew proposal, would you televise the proposed ordinance? Would you, if it passes, would you let the public know what's going on? I know we
I
can
certainly think that would be
set
to our
it at any
benefit,
time.
we could do that.
And who would be the persons responsible for that?
Dr. Lake, the committee discussed that.
Sure. Councilman Buchanan, we did discuss that, and the council would say this is going to be effective on X day. And then between now and then, we would publicize it, we would do PSAs, have articles in the paper, have information at churches, information around the community, at radio stations, throughout our community, so that people will be aware of when this will start. It won't start the day after you approve it in second reading. Y'all will tell us it'll start July 1 or whatever date you choose, and that way we will have time to publicize, and the committee did talk about that. And the committee continues to meet. We are dealing with the truancy issue, so we will talk about it once it's passes the reading, then we will do that.
Would your police chief and your mayor go on there?
Mayor going there.
If they on the air.
I'd like to
Much more
add
than
to Councilman Buchanan's question earlier about stopping the child. This doesn't change anything that's already not a state statute in regards to the child out driving, because there is an intermediate driving, restricted driving license system in place for juveniles, and this mirrors the time frame. A 16 or 17-year-old cannot be out driving between 11 and 6 a.m. alone.
Anyway.
And so that officer already would have probable cause to stop that juvenile anyway. So this doesn't add anything to that. It doesn't grant the police any more extra power. Now, it would for a minor who was out, not in a vehicle. Now, this would give us a reasonable suspicion to stop and check the welfare of that child.
But that's not what your statute says, Captain.
But not
it says, your statute specifically says probable cause.
Well, it does as far as if that child is, if the officer has probable cause to believe that the person they're looking at is underage, under 18, and in a public place, then that is probable cause.
Mayor.
One more question, Mr. Chairman,
Sure.
and I will defer. I am supportive of juvenile curfews, but the language kind of troubles me a little bit. My question is directed into Madison County as a whole. If those who are juvenile delinquent congregate outside of the city limits, if we run them outside the city limits, what have we accomplished?
I don't know that I can answer that question specifically, although this body, of course, this ordinance would only affect the city of Jackson, and this is something that the city officers can enforce. The impact of disseminating a problem outside the city limits, I don't know that I can answer that question here at this time.
Thank you.
I have a question, if I may.
Sure.
Ms. Lake, Dr. Lake, I'm sorry, this was part of the Safe Neighborhoods Task Force, and this is one of the recommendations that came.
Yes, sir.
Do you know specifically where this ordinance was adopted from? Was it from another city?
Well, the state
a combination of-
statutes on curfews, the exceptions mirror, the definitions mirror exactly what is in the state statute. We did call several around the state, Cookville, a number of them, and the process that Captain has laid out follows what most of the cities are doing.
Okay, and those are cities similar to the size of
Similar to our
Jackson.
size, and so we followed them, and only if you cannot find the parent or they're not being cooperative or the youth is not being cooperative, do you take them to detention?
Okay.
So,
And I guess my next question is for the captain.
Yes, sir.
In the past, there have been problems with investigatory stops of youth, particularly in some African-American neighborhoods where photographs were taken of them. And I want to know whether or not pictures will be taken of these youth or not.
As a rule, photographs in that field interview type status, we do not photograph juveniles without consent,
Okay.
as a rule.
And that's your policy?
Yes.
Okay.
Councilman
And,
Udecker.
Lastly,
I'm sorry.
Lastly, I
Go
just have
ahead.
one more question, Mayor, if I may. And kind of echo what Councilman Ellis said. It is based on probable cause, and it's only probable cause that this particular young person is underage.
Yes.
Correct. Okay. Thank you. That's all.
Councilman Udecker.
This is kind of out of order enforcement before all the others, but I wanted to, and I have no problems with the police department handling this with due diligence. But I am concerned about that several discretionary options. These are things that you haven't discussed directly with this council as to how those discretionary options will actually be weighed and what will weigh them. How, when you come upon a young man traveling, how are you going to do this, or a group of young women? How are you going to handle that? What's going to spur one action or another?
Right. I believe the letter of the ordinance outlines a lot of it. The reason why discretion was applied or added into the ordinance was instead of mandating specific things, then it took the reasonableness out of the equation. Just as Councilman Buchanan brought up, if mom is asked Junior to stop and get milk on the way home and it puts him outside of a certain window, does that necessarily mean that juvenile needs to be cited? If we're mandated, then we have to. If we take the reasonableness out of it, if we don't have some level of discretion. What triggers each action by the officer is the facts and circumstances on each situation. And that's another reason why the discretion is in there. If we mandate specific acts to happen, then the officers do not have a discretion when there's a reasonable reason for that minor to be where he is at the time.
But isn't it true that you will train your officers what actions to take under certain circumstances?
Yes, exactly. There will be training on any ordinance that comes out that affects enforcement, so.
So discretion is really not taken or weighed. It's, you're gonna have a set method.
Yes, sir. There will be a set method.
Okay. I defer.
Councilman Wallace?
The other question I've got is Dr. Lake, how long do you think is a reasonable amount of time between when we say we want to make this law, if we pass it, to give you enough time to do the PSAs and those types of things?
About 3 months, couple months.
I think 90 days should be plenty.
Mayor, I had another question, if I may. I'm sorry.
Councilman Brooks?
And it's really in the form of a suggestion. I believe it speaks to that within 6 months, the chief will provide us with a report. If I could, I'd like to have that report maybe a little earlier. Could we look at maybe 3 months? And as well, if we could just get the raw data on a monthly basis.
3 months
I think
from
that
the
would be helpful
effective
to the
date.
council.
Mayor, if I could, like the gentleman said, I did a research, and I went to other cities and tried to see about the curfew and how it works. And it's got a lot of disadvantages and advantages. And if we're gonna try to curb our juvenile crime and get it on some type of control, we have to do something. And we can't keep sitting back inside. I know we got a lot of questions about this, but most of the parties teen parties you have, they open at 1 o'clock at night. And you have a whole lot of problems that take place around that time. I mean, you can't have a teen party now without a fight. And I think the longer they go, the more opportunity there is for them to get upset and get doing some of the things they shouldn't be doing. So I think we have to do something right now to get some type of control and have some accountability for our parents to get back and get the kids opportunity and get the parents opportunity to work with the police officers, because I don't think they're gonna be out just harassing the kids just to be doing it. But we're gonna have to get some type of control with our kids to make sure they're at home like it's supposed to be, because over in my district, I can speak for my district. There's a lot of kids that hang out at the Exxon service station, robbing people every night, waiting for people to leave, walking, and they robbing them. And maybe if we know at 11 o'clock at night, you feel safe going to the store and not sitting around and wait somebody to wait outside to rob you when you leave your house. So I think we have to do something, and now's a great time for us to answer the question, maybe some concerns that we do have for this orders, but we need to do something to get some type of control of our kids in the neighborhoods.
Question.
1 second. Councilman Brooks, if you would hold your suggestion until the ordinance gets moved in second, then we'll take yours as amendment. Is that okay with you?
Yep, that'd be fine.
Okay, Councilman Uzak.
In regards to the particular ordinance, I think it's restrictions, section 103. You've got items 1 and 2 about the difference between 17, 18-year-olds and 16-year-olds and under in regards to time value. Is there a reason for that?
That's in state statute.
But that's not necessarily something that we have to abide by, is it?
No, we
In state statutes, there's no state statute on curfew. There's just, this is just.
Yes, there is.
No, there is a
There's
state
a
statute on curfew.
Is there a state statute on curfew?
Yes.
There's a state statute on curfew that only is applicable to certain counties right now, and we're not one of them.
But we did follow it.
But that's the language to mirror the statute.
But not necessarily the language that we have to abide by. Question to the attorney.
Do we have to do that?
Yes. Okay. That answers the question.
But that is a model for compensation will be considered constitutional legal.
That's why we did it.
The other question I have is, and I guess it's part of a comment as well. And I've heard, and I've said it before, and I'm sure I've heard it from other councilmen. Minors do not have constitutional rights.
That's not true.
And I'm not sure that that's not true, because we've actually put a section in here about exercising constitutional rights. Are we abridging their rights, in your opinion, counsel?
No.
Okay.
If I may,
Okay.
I have it at my office.
I was gonna say, if I may.
Yes.
Mayor,
Sure.
there are certain constitutional protections that children have.
Right.
That's correct.
They're not blanket as an 18, but as the Seventh Circuit Court of Appeals in addressing a similar curfew statute stated, that any curfew that's being imposed will, if it's ever challenged, will be determined on an intermediary status. So I think that's part of our job here today as the council, is to go through and enumerate what the goals are of this curfew and also provide any data that supports those goals. Otherwise, if we don't do our job, then we're opening this statute up for a constitutional attack. And I think that this body does not want to abridge any rights, because we want these 16 and 17-year-olds to go out and learn what it is to be a responsible citizen when they become 18, so they can engage in protected activity, religious activity, free speech, campaigns, what have you. So I guess that's my first question, is what was the committee's goals in fashioning this ordinance? Because that's where it all has to start. We have to have a specific goal that allows this body to function.
Well, we want to make Jackson a safer, better place to live. That was and the charge of the task force was to do crime prevention, aggressive code enforcement. I mean, I brought those to you a couple of years ago, but the curfew fell right into the crime prevention and the safe neighborhoods.
Oh, and that's good, because it's good for us to say, yes, that is a government-protected activity to provide a safer Jackson.
Right.
But it's not enough for us to just say it's safer. We've got to have some type of data to back that up. So my next question is what is the percentage of teen crimes being committed after these hours that we're trying to curb? Do we have that?
The statistic, I think Dr. Lecter y'all has, the number of weapons confiscated by 18-year-olds and less, 17-year-olds and less, and that number was astronomical.
And my question is, are those confiscations taking place during the hours that we're trying to curb here?
Well, I can speak on that. My house was broken into around 12 o'clock at night. So I can speak, yes, it was.
By teenagers?
About a teenager, several teenagers. And several in that area, whole area was a group of kids going around at a certain time of night breaking in people's houses when people's working and people out doing things. A lot of teenagers out doing that.
I think when we analyze this, we have to look at the pre-data, not only arrests, but offenses committed by youngsters as well. But we also have to do the pre-test and then do the raw data and calculate it during the period of time so we can see if there's a difference. Now, the other, I've done the research. There's been a lot of discussion in the public comments about what is the research on a curfew, and I have looked at it, and it is mixed. But I will tell you that in certain cities, for example, in North Little Rock, they saw a 12% reduction after they did their curfew in violent crime and a 10% reduction in burglaries. And in Denver, they saw a 17% decrease year one in motor vehicle theft, which you know is a prominent crime that occurs during these hours. They saw a 23% year two after the curfew in motor vehicle theft and a 11% decrease in serious crime. Several studies have not found any decreases, but equal number have. And I've looked back, these go all the way back to 1994, these studies that have been done on a curfew. I think there are four important things if council approves a curfew. Is the community has to accept it and understand it. I think that's critical, and that's why we need the time to make sure that people understand it. Number one, we have to have consistent enforcement in that the law enforcement follow the ordinance here and use their discretion in how they implement and make it effective. We also have to have accurate record keeping, which goes to, are we effective? And I think the fourth thing that this committee is working on under the leadership of Mayor Gist is the truancy issue. I think curfews at night are important, but you're going to have to deal with the day side of it as well. And I think collectively, these together, we can have a true impact on the youth crime and arrest in our community, but I think they go hand in hand, and we're bringing this one to you first. And then we will bring the truancy piece to you second. But I do truly believe they go hand in hand, and together we can make a huge difference in our community.
Well, Dr. Lake, please don't get my motives wrong here,
No.
okay? Whether I vote for this ordinance or not, it is my job as a council to make sure that if we are challenged constitutionally,
Sure.
so we need to make sure that all this record
I
and
agree.
data that you have needs to be submitted
I agree.
to the council and put into a
Needs to be part of the record.
part of the record.
I
That way,
agree.
if Mr. Cobb has to attack
very
this or
important.
challenge this, not challenge, but to defend this from an
Exactly.
attack,
I agree.
he has the data with which to do it.
I completely agree.
And so I would like for, to be placed into that record by the next council meeting, the statistics of teen crime after the hours of the curfew that it's being imposed, as well as any studies that you've referenced or any materials that you all have referenced.
And this is in regards to juvenile crime, is that correct?
That's correct.
Right.
Yes, and all my.
And between
my-
these hours as well, right?
Exactly, and it
Yes.
needs to be between these hours that we're specifying, because that's what we're trying to curb.
Sure.
And I just want to make sure that we're not, as a body, asserting our own, where I would not want my child to be out, past 10 o'clock, considering they're 7 and 3. But are we, as a body, trying to impose what our philosophy on parenting is? Or is this strictly a crime enforcement deal?
I would respond, it's to make our community a safer, better place to live.
Now, if this is a big issue for me, this is the probable cause issue. You made an issue, or you made a statement about reasonable suspicion. What criteria is an officer going to use in pulling somebody over, or coming up to a group of individuals on a street to ascertain? I mean, other than you look like you're under 18.
Right. The response from law enforcement is going to be 2 or 3-fold. The way this can happen, we may get a call from someone about juveniles in the area, so we're going to have to respond to that, and we're going to be on the scene there, and we'll have to deal with what we have. We may be on a call or at a business location or anywhere else in the public, and just come across it. The issue I think most people are hanging their hat on is when we're just seeing someone walking down the street, and what gives us the grounds to stop. And the only thing I can say is that we're going to have to, because this is directed toward juveniles, that the reasonable suspicion, and the only reason why I brought that up is because it's a lower standard, and if you have probable cause, which is based in there, you're going to have the reasonable suspicion anyway. But if we see a minor, a juvenile, in a public place, that's going to have to be, we're going to have to at least stop and find out, is this person underage? Certainly there are going to be people that are 25 years old that may look like they're 16, but we won't know till we ask. And so it may even begin as a brief, just police encounter, consensual. Can you tell me how old you are? And if they say I'm 25 and got an ID, then the stop's over.
What happens if the person doesn't want to respond? They say, I don't have to
Well,
tell you.
that again, we're going back to, do we have enough to make the stop and the detention? If we don't, then the officer's going to let that person go.
And that's my question, is
Nothing there changes.
Is a person's youthful appearance enough to justify a detention?
No, it's not, but it's enough to inquire.
And if they don't inquire, if they don't respond to the inquiry and they choose to walk away,
They're going to have a reasonable suspicion to detain them or probable cause to keep them. One of the two. If it's not there, it's not there.
If I may, I think, and Dr. Lake touched on this, it's very important that it be enforced consistently. And, in the large sense, it's going to target pedestrian traffic as opposed to motor vehicles. Do you agree with that?
I agree with that. The motor vehicle stops will probably not be as many.
Right. And I would suggest that there are certain communities where you have more pedestrian traffic at night than others.
Some.
So I just think it's very important that 38301 be enforced the same as 38305, and there will be some differences because of what I just said.
No doubt. The key to this is that, and I'm glad there's going to be a 2 to 3 month window there, because we do have to train the officers in what the ordinance reads and how to enforce it. But the key there is, do you have a possible violation? If you do, address it. If you don't, move on.
Question.
Go ahead.
This is for legal counsel. a question in regards to, in your opinion, does the mayor have the power to implement this on an emergency basis already, in your opinion?
I would say probably,
Yeah. Okay, thank you.
Any other questions?
Mr. Chairman, it piggybacks on yours, Councilman Ellis. Was the question answered with respect to the juvenile crimes? What time frames are they happening in, proposed curfew time versus unproposed curfew time? Was that ever answered?
We looked at youth brought to detention. Amy Jones is with Juvenile Court Services.
Amy, you wanna come on up if you would, so we can have you part of the record. Amy is Director of Juvenile Court Services.
What we did was we just pulled 2 sample months when the committee was meeting. We pulled March and we pulled June of 2009, so that we had 1 month of in school and 1 month of out of school. What we found is that the crime, the numbers were split about half and half between crimes committed during the hours covered by the curfew and crimes committed during the school day hours, what would have been the school day hours. So our position is that the curfew can and would be effective if we pair it with a strong truancy ordinance, and that's what the committee's working on. Now, I will be more than happy to have for the next committee meeting, I can pull the data for a year's time and restrict it to just crimes that happened inside the city, because we just pulled all of them, which would have included things out in the county too. So we can restrict that. We can get more data and restrict it to just the city.
Can that be made part of that package
Yes, sir.
of information
We
that's
will.
going to be
And I'll do my
included in the
literature
record?
review with that.
And I'd like more than just 1 year. I'd like at least a couple of years so we can compare from year to year to year.
Yes, sir. We can collect any time period that the council feels appropriate.
I just want to make sure that I understand this, that this sample size that you drew from involved Madison County as well, an area that we will not be affecting.
Right.
So our sample is, I don't want to say tainted, but it is tainted.
Right, right.
I'm curious as to, Mayor, if I may have the floor, I'm sorry. The ordinance in and of itself, is this a criminal ordinance or is this a civil ordinance? Because I did not see what type of, it says it'll be issued a citation. Is it a civil citation? Is it a criminal citation? And if so, what would the minor child be guilty of or the parents be guilty of from a criminal aspect of it?
I've spoken to Roger Jowers, who's our representative of the Tennessee Commission on Children and Youth. He monitors our detention center. And the way he explained it to me is that a child violating the curfew ordinance is guilty of a status offense, and that's how they would be processed through just, a status offense being a crime, something that's only illegal because a child is doing it.
So they'd be adjudicated ruling and delinquent unruly, or because we reference neglect,
right?
With the means to hold them, and that was going to be my next question: is what bodily harm is that child undergoing by being out after 11 o'clock?
It was my understanding that the neglect part applied to the parent's lack of supervision of the child. The child would be adjudicated delinquent under as a status offense under the curfew ordinance.
Ms. Jones, excuse me if I may. Were you finished, Councilman?
I'll defer right now.
Okay. My question was similar to Councilman Ellis. The child would be adjudicated through the juvenile court system.
Yes, sir.
Okay, and that's a criminal matter.
Yes, sir. It's a matter of juvenile crime.
Right, and the adult would have civil penalties that would follow.
Yes, I believe the statute lays out fines that would be assessed against the parents. It's my understanding there's an agreement between Judge Little and Judge Anderson that would allow Judge Little to assess those fines, since she would also be hearing the child's charges.
Okay, and would those fines go to juvenile court?
I believe so.
I'm looking at Juvenile Court Clerk Bart Swift. Those fines will go to juvenile court.
Okay. Ms. Jones, were you instrumental in drafting the statute at all?
I've attended the committee meetings, participated fully, yes, sir.
I I have another question about
Thank you.
constitutional.
Good. Councilman Allen.
We've got a fine of $50, but upon subsequent offenses, it increases by $50. And I know that as a city, being a municipality, we can only fine $50 without a right to a jury trial. Is that going to infringe upon that constitutional right if we? So we'll need to change that. It's specifically, it's section 105B, subsection 3. It'll be on the last page of your ordinance.
The fine's on the parent though, not the child. Would that make any difference to any?
I think it would if it's on a parent. That's why I'm questioning it.
I think the parents are treated as adults in federal sessions court. Maybe since it's not a municipal court hearing, that's a federal sessions court. I think it's different.
You think it's a different animal altogether?
I think so.
Okay, even though that this is a city ordinance that they would be enforcing. That's my question is, since this is something that's being enforced or being drafted because of the city, then it's the county that's enforcing, but it's the city ordinance that they're enforcing. That's what scares me.
You may be right. I'll let you know.
I just have a couple more questions. I like the idea that we have discretion with our officers, but my first question is if an officer with reasonable suspicion stops an individual, do they have to inquire as to the exceptions to ascertain if there's an exception to the violation of the curfew law? Do you understand my question?
I believe I understand your question. If an officer has reasonable suspicion to stop someone because they believe a crime is being committed, or has been, or will be, and during that stop, they ascertain the age of the person, that person fits in this framework of this ordinance, then yes, they're going to ask the questions, why are you out at this time? Do you have a reason for being out? If they fit within the exceptions, then as far as this ordinance is concerned, there is no violation.
And piggybacking off of that, under this ordinance, if a community event is going to take place, we have to notify either the chief of police or a representative to I guess, certify that activity. First of all, the chief or the representative isn't going to say you can have that activity or not. They're just being informed.
Just a notice.
Okay, and my next question then is at the beginning of each shift, midnight shift, are we going to tell all those officers, okay, there's a basketball game tonight, there's a Inglewood's having a function, North Jackson Church of Christ is having a function.
We do that now.
We do that now.
Yes, anything we're aware of that's going on is relayed at roll call. That's correct.
And if a individual is stopped, and they're saying, I'm coming back from Burger King, working at Burger King, but they don't have a note from the employer, are we going to contact the employer, or how's that going to function?
Again, that's where the reasonableness comes in. The officers that work these timeframes and in these areas, I'm just stating that if we stop a juvenile if we stop him for a traffic violation, we ascertain that he fits this as far as age, and we ask, he's on the way home from work, that's going to be something we can check, and if we need to. If we think that's a reasonable time period for that, for Burger King closes at 11 and it's 11:30, that's fine, then they're on their way.
Well, the reason I asked that, Captain Corley, is because in your ordinance, there's no discretion. It says must be carrying a written note. That's a obligatory, that's not discretionary. And I'm looking at section 104, subsection 3, it's the very last sentence.
Well, excuse me, but that's where our public relations comes into effect, where we will, let people, the community know that with this ordinance, if you've got a young person between these ages working past these hours, you need to provide them when they leave written notice. And that's just something that we will advertise and make sure people know.
Let me make a comment on
Sure.
that.
Mm-hmm.
I don't know if we discussed this, but
This goes, my name's Bart Swift. I'm on the committee for this truancy and curfew committee. And this is not my juvenile court experience, this is my restaurant experience, but there are state laws that disallow someone under the age of 18 from working. I believe it's weekdays. If you're 16, you can only work till 10, I believe, and then like 11 o'clock on Friday and Saturday night. So I think those laws fall actually below what this.
But 17, there is no restriction from my memory. But I'm not an FLSA. I'm not a Fair Labor Standards Act attorney.
Well,
so
I'm 5.5 years out of the restaurant business, thank the Lord. So I can't really remember. But there are laws restricting juveniles from working late hours, and so I don't think that's going to be an issue where, except the issue of a child if they're working till midnight on a weekday at Burger King. I think there's more issues than just the curfew, I believe. So,
Dr. Lake, is this time sensitive, the ordinance?
Well, we would like to have it voted on, yes, sir, soon. But it's at the pleasure of the council, but we certainly would like to, the committee has been working on it. We've met since December, and we would like to get this part done so we can move on to the truancy piece and bring that to you as well. But
That's a no, but kinda,
sorta.
Okay.
If I may, just one more. Going back to this whole idea of religious activities, if St. Mary's is holding a midnight mass, that's going to, I don't know how long their masses go, but if it goes past 1:30, is St. Mary's going to have to call in to the chief and say, we're having midnight mass and we may have juveniles attending there?
Yes, sir. Our church has midnight mass every Christmas Eve, so.
I think the law says that if it's not generally known, and I think
But
midnight mass, Christmas Eve is generally known that St. Mary's.
It's in the paper that those midnight masses occur.
Here's the way I think it will work. There's a law that says you've got to have proof of insurance, current insurance with you. If you stop for speeding, they ask for insurance. If you have a card that's a month or two old, they can write you a ticket or not, depending on their discretion. And that's the type of thing I think the law says you must have it. If you don't have it, then the officer makes an evaluation, just like you would with the piece or the registration, something like that. It is required, but it doesn't necessarily mean that you'll get arrested.
Thank you.
My last question, this goes to enforcement. Captain Corley, are we going to increase the number of officers during this time? And if we aren't, then how long are we going to allow officers to investigate a minor or group of minors, to call the parents or the legal guardians or what have you before they decide that they're going to need to take those children into the detention center?
There's certainly no plan to hire more officers based just on this ordinance.
It just seems very onerous for the officer to go through all these exceptions to figure out what's going on.
Well, that may be, but that's something that we deal with now. If an officer or officers believe or have reasonable suspicion that their crime may be committed, may not be an ordinance violation that we don't have yet, but may be disorderly conduct or anything else, they're still going to stop. They're still going to ascertain who these folks are, and none of that changes. All this does is add one more thing in the mix that we have to say, okay, are they in violation of the curfew as well as anything else we may be investigating? So I don't really believe this is going to add too much more. The only time constraints that may be involved, again, that would be additional, was if we contact the parents and waiting for parents to arrive or transporting back to a parent. Other than that.
Well, I could, on that, based on the research that I did, it said after we get the curfew under control, it will free the officers up to do the more work they need to be doing in the streets as dealing with our kids. That's basically something the city stated, that it will give them opportunity to do other work besides dealing with the teens at that time of night.
Okay, any other questions or comments from council? What we'll do here, I know there's an amendment waiting, but let's get a motion for approval in a second, then we'll.
I can make a motion to accept.
Okay, we have a motion. Is there a second?
Second.
Okay, we have a second. Discussion. And
I'd like to make an amendment if I may.
I think we have one waiting. Councilman, I'll come back to you. Councilman Brooks, would you like to?
Yes,
make your
Mayor.
amendment?
The amendments that I would like to make is that that we would like a quarterly report.
90 days after the effective date of the
Yes, sir.
curfew?
Yes.
Okay.
And,
Rather than 6 months?
Written, yes, absolutely. We would like a written quarterly report, and that we would like the raw data on a monthly basis, if we could. And I assume that would just include the information that's on any arrest report or incident report. All of that information would be.
Okay, we have the amendment. Is there a second to that amendment?
I'll make a second.
Okay, we
Mayor,
have a second
before we vote on
discussion. We're voting on the amendment to the ordinance,
I wanna make sure I
indicating from
understand the
6
amendment,
months
though.
to 90 days
All right.
for a report back.
He said he wants quarterly reporting.
No, just a quarter of the raw
3 months from
data.
now, you want to report.
Yeah, just the raw data quarterly, but the raw data on a monthly basis, but the full report from, I guess it would be the captain and the chief of police.
Okay, let's go back to the raw data on a monthly basis. Is that part of your amendment?
Yes, sir, it is.
Okay, how is that going to be generated, Captain?
That would be generated from, I would assume, from maybe a combination of both from juvenile court services and the police department.
Okay, but that's a doable thing to provide that.
Yes, sir, that would be
raw
doable.
data to each council person monthly. And then we're going to back off the 6-month report from the police chief and back that down to 90 days. Is that correct?
Yes, sir.
Councilman, okay. Okay, everybody understand that amendment? We have a second. Any discussion? Council-
Discussion.
Okay, I have a question.
On the motion, what is the motion?
Okay, you're
Are we
voting on the
ordinance itself or just the amendment?
Just the amendment. Okay, any other questions? Okay, council, please vote.
And the vote is unanimous.
Okay, we have that amendment. Is there other amendments?
Yes. On section, in regards to enforcement, section 105, I would suggest that we remove, I believe it's under section B, item 3, until, which has the subsequent offenses involved, increasing by $50 for the second, $150 for the third, that we remove that until council can examine the legality of that particular motion, of that item.
Okay,
That last sentence.
is that the $50 fine that juvenile court could levy against the parent?
Yes.
And that would be the maximum?
Yeah, it's the other offenses, the subsequent offenses, that's for each subsequent offense, that section be removed. Until council can determine whether it is legal or not. That's my motion.
We have, okay, that's, okay. Any comment from
That would
Captain
remain
Corley?
$50 per incident though, but it would just not increase per
Correct.
incident.
Okay.
Correct.
all right.
Just $50.
We're just removing the,
$50,
okay.
from the point from for each subsequent offense.
Like
Okay.
that last sentence you won't remove.
Right, yeah.
Okay.
Okay, we have the motion. Did we get a second on that?
I'll second it.
Okay, we have a second. Any discussion? Council, please vote on that amendment.
And that amendment passes unanimously.
Okay.
There is one more section that I guess maybe I'm trying to ask about the information, the data, the raw data. This is data we don't have now, or we don't have compiled now. Is that correct? Or
We looked at the 2 months that Amy Jones described in the committee, but certainly the incident reports and the data exist of
But
where
it's-
we are in the current state.
But that included the county also.
Right, so
And
I thought
that's
next
really
month
being
y'all
valid.
ask us to bring back a couple of years of data plus the literature review on what the other communities. I thought y'all wanted that back next month.
well, let me ask one more question then, because it all has to do with an implementation date. You know, when we implement this, as to whether or not we have that information in front of this council.
The baseline.
Again, I'm mirroring Councilman Ellis's questions in regards to whether we have enough data to make any kind of assertion between point A and point B.
Right, we need a baseline.
We need a baseline.
That's right. And I thought that's what you wanted us to bring back next month.
Yes. So my amendment would be that even if we pass this first reading, that we have an implementation date that is suitable both for you, because we're looking at a time frame as well, that if we would put an implementation date of, let's say, July 1st of this year, 2010, if that's an
Okay.
acceptable date by this council.
I think that would be 3 months after we approve it, if we do the second reading, which I think is what she said would be. So
Yeah.
I would second that motion. The July 1st be the implementation date.
Could you repeat that motion for us?
Okay, we have a motion that the implementation date of this ordinance, if council passes it as amended, be July 1. Do I understand
That's
that
correct.
correct?
That's
Okay.
correct.
And that should give adequate time to get the data
Yes, sir.
provided. Prior to the implementation date, is council still looking for a monthly raw data report?
Yes.
Is that possible, Captain Court?
We can
Okay.
provide.
That's
I
my
thought-
fear, is that we're putting
Well, I
an
thought
artificial limitation on this.
I thought
Let's-
there, Councilman, I thought we're gonna have a baseline that says where we are now, and then once it's implemented, you want the monthly, correct?
Right.
Councilman Newton, that's
That way we'll be measuring something.
correct, so that we'll have our baseline where we are now, and we'll see if we've made a difference.
Baseline next month as to where we are now.
Yes, sir.
Before we
That's
do the
exactly
final
right.
vote
The
on the
second
ordinance, that
reading.
we
Yes,
have
sir.
the
That's what I
baseline that
thought.
we're going from.
Yes, sir. That's what I understood you wanted.
The
Okay,
baseline
now we
last
have-
2 years worth.
But it gives us plenty of time.
We have, as a third amendment to this ordinance, a implementation date of July 1st. Is that all that needs to be in that amendment?
I think so. Yeah.
Okay, do we have a second on that?
We already have a
We
second.
have a second. Any discussion? Council, please vote.
That motion passes 6 in favor, 2 against, and 1 abstain.
I have one more item that I'd like to install in this particular package, and it make me very happy if we did do this. I think everything should have a beginning and everything should have an end. We should put a time limit on this particular ordinance of 1 year. It should come back before council each year.
To review the statute every year.
Is it, Ms. Cobb, is council could, if they're unhappy with the ordinance, the way it's being conducted, could rescind it at any time? With one reading or two? Yeah, you do have that option, members of council, to you can tie a year to it, or you can come back at any time and ask for a decision of it in 2 months, first and second reading to rescind the ordinance.
Well, my reason for that is it brings it back to us automatically, and that way we can review the information and the data, and we can see if there's been an effect, a real effect.
Okay, is there a motion? Come back each year and review
Motion.
the
I'm
ordinance?
making
Is there a
the motion.
motion? There's a motion. Is there a second? Motion dies for lack of a second. Any other discussion, any other amendments that the council needs to consider?
I have one question real quick. If a parent just says you can stay out past 11, because the 1:30 that we're talking about is if there's an activity. The real curfew is 11 o'clock. If a parent says you can go to Johnny's house, be home by midnight, or you and Johnny can hang out past midnight if you want, is that enough to fit under exception, or does there have to be a specific reason? Do you understand my question? Can I just generally give, as a parent, my child permission to stay out past 11 o'clock if they're home by midnight?
I think if they're out alone, they're gonna have to have some,
One of the exceptions.
one of the exceptions, or after 11 PM, they're in violation.
Okay. Any other questions from council, any other comments? Okay, we have a motion to accept the ordinance and a second. You have two amendments to that ordinance. Any questions about that before we vote on the ordinance as amended? Any discussion? Council, please vote.
Motion passes 6-2.
Thank you. Thank you. Thank you, Amy. Item 2 is consideration of the first readings. Consideration of ordinance to amend Title 8, Chapter 1, City Code of Jackson, Tennessee regarding liquor zones. This is first reading.
Morning, Mayor and Council.
Morning, Al.
Basically, I would classify this simply as a housekeeping item, and it follows the procedure that I thought we were going to take with the codification, because in the process of looking at the existing code, it became obvious that there are 6 liquor zones, and we have, for however many years, only addressed restrictions on 4. So we were simply taking the wording for liquor zones 2 through 4 and the 300 feet restriction, and we're changing that to what was originally intended. No question there, liquor zones 2 through 6, 300 feet. So it's really just a housekeeping item.
Motion for approval?
Second.
Okay, this is the first reading? Yes. Okay, let's get a public hearing. Is anyone in the audience who'd like to speak in reference to the passage of this ordinance, either in the affirmative or the negative? If not, we'll close
I'm sorry.
public hearing. And do we have a motion for approval? I think we do. And a second.
Yes, sir.
Discussion.
Yes.
Yeah, question just very quickly. Since we're have to have a first and a second reading, can we go ahead and amend the language from not just the number of zones, but as to one location where it's prohibited, and that being a library?
That was not published in the public notice. This was what was presented and was available in my office, and I think we have to stand by this and come back and do another.
And do another one?
Yes.
Yeah. Okay, any addition? Yes, Councilman.
Al, what is the difference between liquor zone 1 and why is there only 100 feet there?
That is and Stan can comment on that, it's the area downtown.
Number 1's downtown, so you have to think close. Okay, that's my question. Thank you.
But just real quick, this is an ordinance. We're amending an ordinance, not a codification.
We're amending an ordinance that's part of the current code.
Okay. Council, if it's an ordinance, can we make an amendment to an ordinance
Yes.
on first reading?
Yes.
Sure.
Then I'd like to make a motion that a liquor store shall not be located within a library, 300 feet of any, to include in the section any 300 feet of any church, edifice, school, public park, or playground, and include public library.
I'll second
Mr. Cobb, is this not an amendment to the original ordinance, which obviously was left out years ago?
Right.
And so I guess, are we talking about an amendment to this existing ordinance, or are we talking about a new ordinance with a new zone?
I know the liquor laws are strictly controlled and mandated by the state, and I know there's some exceptions on locations. I don't know if library is an acceptable one or not. I just don't know.
Would it have to be a public library?
Well, I'm not even sure about that.
And then I'll withdraw my motion until we can have an opinion.
I'll be glad to take a look at it and see
And I'll just
what our
propose it.
latitude is.
I'll withdraw my second.
Okay. Motion's been withdrawn, second's been withdrawn. Do we have a motion and a second on the first reading?
I believe we do.
Okay, all right. Any discussion? Council, please vote.
And the vote's unanimous.
Into item 8 under second readings, consideration of ordinance adopting and enacting a codification of the ordinance of the City of Jackson, Tennessee.
I would like to clarify, because evidently I have done a very poor job explaining what a codification is, and I accept that responsibility. Mr. Cobb has clarified that the codification by MTAS is nothing more than taking the ordinances that you as a council passed from 1998 through June of 2009 and integrating them into the code. Now, you passed a multitude of ordinances, but some of those are just to close an alley, so they're not considered in this. Or some of them are to establish a budget, which then is nullified by the next year's budget, etc. There ended up being 35 individual ordinances that needed to be integrated into the code. MTAS did that. They did not touch any of that language. The second part of what we paid them to do was to look at our code where it conflicted with the state code. And that was spelled out, and I provided that to the council. Here there were 9 items that they addressed specifically that they changed, and then there were 16 items that they recommended change. Some of those we accepted, some of those we denied, like they wanted us to have 1 building code reference. And our building department felt that we needed 2, so we denied that. So I guess my frustration is, if you can't sense that, is that I have answered every single question that has been put to me in writing. The most recent one, I met with Councilman Wallace and Newdecker and Councilman Bray, and we addressed, Randy, your questions concerning paragraphs 4 and 6 on Title 6, Section 11, and you questioned whether they had rewritten that. And actually that was established in 1974. And I think we proved that. I pulled those documents. Then you questioned Section 2207, and Mr. Neal from MTAS proved that we had the same language in there that you wanted in there, if you looked at the code that I sent you within the last 2 weeks. So I'm somewhat at a loss, because I think the procedure should be, and I would ask Mr. Cobb to comment on that, the change that we just presented on the liquor zones, I think that's the way to go about something. We paid MTAS $10,000, and they had a team of lawyers, and it took several months for them to go through the code. Now, I know we have a couple of attorneys on the council, but you can imagine the time frame it would take for you to go through and do what MTAS did. So it's just my recommendation, which doesn't carry much weight, that we go ahead and pass this on the second reading. There may be 50 changes that need to be done to the code, but there's a process for doing that. And I'd ask Mr. Cobb if he agrees with that.
Mr. Chairman. Mr. Chairman.
Go ahead, Councilman Buchanan.
Move we adopt the ordinance.
I agree with Mr. LaFuna.
Second.
Okay, we have a motion to approve on second reading. Is there a second? Any discussion? Council, please. Okay, we have one
Just one
item
question.
for discussion.
And it has nothing to do, because I think you did an excellent job. I don't think council is questioning your work at all. I think the question was whether, it was a matter of procedure, whether or not we should proceed as it is and then come back, or we should go ahead and make those changes now. And I think that was the only real question.
Okay, any other comment or question? Council, please vote.
And the vote passes with 7 members in favor, 1 against.
Thank you. Under item 9, under new business, consideration of a lease agreement between the City of Jackson, Tennessee and Cosmopolitan Funeral Services.
Move for the approval.
Second.
Have a motion for approval. Second. Any discussion?
None.
Council, please vote.
Vote unanimous.
Item 2 under new business, consideration of request by C&C Wine and Spirits doing business as Old Hickory Package to relocate from the present location at 2030 North Highland to 2710 North Highland, subject relocation being within the same liquor zone and contingent upon being in compliance with Section 8-115, location of liquor stores in liquor and zoning districts.
Let me just give you a little history on this because it is somewhat confusing. In November of 2005, the council did approve the request by CNC to move from their present location, 2030 North Highland, to 2708 North Highland. But during that time frame, then between 2005 and 2009, and I don't know the exact date, but the Montessori school, which was further north and was beyond the 300-foot restriction, expanded into rental property owned by Dr. Cross, and it was within the 300-foot limitation. So on October the 6th, 2009, when CNC applied to move from 2030 to 2710, because the 2708 was a lot at the time, which was then subdivided. So 2710 actually moved them closer to the Montessori school. We withdrew that from the agenda. So I said approval denied. In December, they came back and wanted to relocate to the University Parkway Center. And as Stan and I determined, that was right on the line, but it was out of the district. So now they have come back and they have requested to put this on the agenda with the contingency that if and when the Montessori school moves, that they could proceed immediately without having to come back to the council. And they're doing the same thing with the state. They evidently, supposedly have word that the Montessori school will move.
Okay, any questions from council on this item?
I have one. Let's say before Montessori school moves, a church gets a rental property on the other side. Are they barred? Is the church barred from locating there, or is the?
It's not just the Montessori school, it's contingent upon them meeting that.
Meeting everything.
Right, yes. And Mr. Cobb, I think there's a comment in there from him, his opinion that even though there's no statute of limitation on the November 1st, 2005 approval, there was a period of time that elapsed that needs to be brought back to the council.
And I think that was well intended, but it probably would be prudent for us to do some due diligence because we're seeing quite a few of the relocation of these stores just within the past year because of shift in population, whatever, moving within the same district. It may be prudent to look forward, and if we approve a location for a liquor store to go within their district at a certain location, they start working on the architectural plans, doing their surveys and getting all that done. And in the meanwhile, a church, whatever moves in within next door. Is that currently handled through rezoning? Stan? I mean, would you deny them and this, you know, a right to put their church next to a proposed site of a liquor store?
No, if a church decides to be next door to a liquor store, of course, that's their right to do that. It doesn't make the liquor store illegal because the liquor store is there, and the church is not illegal because it's next to a liquor store. So if the church got approval through the Board of Zoning Appeals to be in a location and they chose to be next to a liquor store, then they could do that. But if an existing church is already in place and you have a vacant lot and a liquor store wants to go, then they are barred because of the requirements say they have to be a certain distance from the church. So,
Mr. Chairman.
Go ahead.
Just a question on time frame. I guess this is a chicken and egg kind of question. Was the approval for this liquor store in place before Montessori went in?
now, when you start getting into approvals, that's an area outside my expertise. I'm just talking about uses, and I can't. To me, it becomes a legal question or a procedural question of what institutes approval and establishment.
In 2005, there was a consignment shop in this building that Dr. Cross owned, so it met all the restrictions, but then the liquor store did not take any follow-up action to break ground, and that's when the Montessori school moved over.
So they have to break ground before a school goes into place for the exception to,
No. But 5 years ago, a request to move was sought, and at some point, what if it was 100 years ago? At some point, the permission to move lapses. They got permission to move, they didn't move, and then things changed. And so somebody, the mayor's office, the planning office asked me to look at that, and it was my considered opinion that after a certain period of time, if you don't exercise the rights that's been given to you, you abandon them.
so you're suggesting, like the mayor has stated, that we put a time frame. If you get approval, you must relocate within.
Would be my recommendation that if you don't, there's no law on this, there's no cases on this, and trying to apply some common sense to it. The reason it's before you today is to determine the suitability of that location. One of the issues is what's around it. And at some point, I think common sense says if you don't exercise your rights, you abandon them. This is an unusual request, a contingent request. My recommendation would be is to consider putting a 6-month period of time or some reasonable period of time that if it's not exercised, it's abandoned. That's just sort of a common sense
Or at least
application.
some progress being made toward trying to get
Right.
it within 6 months, depending on construction
And
time.
the council also can amend the districts if it were to choose. That's something the council can do as well. If there was a place that was that close to a district, you could consider doing that as well as to provide a solution. But
Thank
and again, as Stan said, a church can move in right next to a liquor store. It might be a good place for churches, you know? But we do believe that liquor stores might bring an influence into the church or school or other locations, would consider unwelcome, and that your job is to protect and to evaluate that. Does that answer your question?
Thank you, Mr. Kyle. Okay, is there, do we have a motion to second on that? We do, okay. Any additional questions? Council, please vote.
What are we voting on? I'm sorry. We just voted on letting
We
them move?
did, somebody said we had a motion.
With no limit?
we didn't.
No motion, I'm sorry, okay, let's have a motion.
I'll make the motion.
But we have a motion. Is there a second?
Second.
Any discussion?
All right, now, we're just letting them move with no limit on how soon they can be there? Or how soon they've got to build?
Well, we know they can't move in until the school relocates.
Okay.
Well, we can mark that one off. And as far as the time frame that they would have to build a building, move into it, someone build a building for them, at this particular point, there's no time limit.
Okay.
Am I correct there, Scott? It's reasonable?
Well,
No reasonable
so
time
can I make
given
an
in the
amendment
ordinance.
that they've got to, be moved in within a year after the Montessori school moves? Would that be reasonable?
Can that be
Well-
set as part of the motion, Mr. Cobb, or does that need to be by separate ordinance?
I think they could put that in, I think you could amend the ordinance.
I will interject that when we are dealing with land use and we're putting things on the map in terms of land use, we often use our building permit to determine when we place if somebody pulls a permit for a single-family dwelling, we put it, we know that's gonna be there now. So that's the general rule that we use, and if somebody was asking me if something was located and we pulled our map, it would be based on them pulling a permit to do something. It would not be based on some idea in their mind that I'm gonna do something.
But there's no termination date for building that
No,
residence with that building.
I think the
permit.
building department gives some latitude on once they pull a permit. I think they have a certain time frame to follow through and do something, but it's reasonable.
Okay.
Okay, I guess I won't make a second. Never mind.
Okay. All right, we have a motion. We have a motion, and I think we have a second. Is there any discussion? Council, please vote.
The motion passes 6-2.
Okay, item 3, on the new business consideration of the wellness policy for Jackson, Madison County.
So moved.
We have a motion.
Second.
Second.
Question? Question?
Okay, we have a motion and a second. Is there any discussion?
Yes.
Councilman Udine.
Please Be seated. I've got a lot of questions in regards to this particular policy. One of those things has to do with the adding of sidewalks to existing major streets, which I'm assuming was placed in here for existing streets and roads.
Yeah, walkability, based upon available funding. What we try to do in the wellness policy is to look at the total city and look at communities that are underserved with sidewalks, look at existing sidewalks that we could upgrade and better promote physical exercise in terms of people being able to walk to school, walk to places of retail, et cetera.
My question is, when you talk about funding,
yes.
Is it something that we're going to actually put in our budget?
Well, if funding is available and there's indication that there's money available, we would look at what we feel would be necessary to do. It wouldn't necessarily be a broad program. It could be incremental in terms of how we approach it.
I think if council approves a budget for 200 miles of sidewalk, then that certainly would be a part of the wellness. But however, if the council does not pass the funding for 200 miles of sidewalk, we still have a wellness policy, and we'll do it when we get the money. Or build 200 feet of sidewalk.
Right.
So most of this is, and I think this came up at agenda review, and I think it's been modified. Dr. Lake indicates it has. Any construction, any funding from this body would have to be contingent upon having the funds available to do it and approved by council.
That question answered to a point. I'm not familiar with the coordinated school health efforts. Are you familiar with that?
Yes.
Okay.
Yeah.
Can you explain that to me? And the nursing program.
What has happened, the state several years back mandated to school districts that they have on site as a part of the school district a health coordinated individual who's responsible for looking at the menus, what is served in the schools. And out of that process, they are developed a relationship with the city of Jackson, the Recreation Parks Department, to fight childhood obesity. A few years back, the council passed a recommendation resolution that we would, and it fell upon my department to be a part of that. And we have partnered with the school system to look at ways that we can work with them to implement a universal program for particularly childhood obesity, but not limited to childhood obesity, but to look at a total community in terms of how we are eating, the type of things that are served in our vending machines within the school system, and to also, after they leave school, to have it linked with the recreation program so that they have a continuum in terms of healthy choices. And we've been partnered with them now for roughly about 4 or 5 years.
So I guess my question is, really, that doesn't need to be part of the policy. We already are actually following the policy.
In the sense that what most communities have done is that to set a tone for a total community, most communities have developed a comprehensive wellness policy, and that is included in the overall wellness policy, because what we find out is that if we set an example in terms of promoting a healthy community, then a lot of the things and activities that we base it upon has a foundation of support. And statistics have shown that most communities, when they've developed a comprehensive wellness policy, it attracts, it only enhances the community. It also helps in tracking industries, because companies look at what type of environment their employees are working in. It also allows us to be forward thinking in terms of providing these type of outlets to promote good quality health. So
but again, I mean, we're already doing this particular program.
But we don't have an official policy. Yeah.
Okay.
It's not an official policy. And this is for it to become an official policy.
It's similar to promoting a wide range of opportunities for all citizens of all ages. We're talking about through collaboration of other existing bodies. I mean, if we're going to promote it, do we need it in the policy?
I think it would be good.
All right. Partnering with Tennessee Department of Human Services, Jackson-Madison County Regional Health Department, Jackson-Madison County General Hospital, and other providers to publicize low and no-cost health insurance programs. Where does that fall in our wellness policy?
Whether that's fall in our wellness policy?
Yes.
Well, we want to promote quality health thought processes from all citizens, those that are low income, et cetera. And by linking with that and promoting that, that promotes the idea of a healthy community.
But I'm questioning whether or not those policies needed to be in this particular, I mean, that's a political statement, not necessarily a.
That's a matter of opinion. I mean, I don't think it is.
Okay. Promoting smoke-free parks in the city of Jackson, Madison County.
Yes. Yes.
Okay.
It's like we have a collaborative agreement with a number of health agencies.
Yes, we do.
Obviously, being part of a wellness program, you'd want to bring them in.
Sure.
And this is the policy, this is the official policy, which bases everything that we do on this policy, which is a formal policy. I guess you could do anything you want to under an informal policy. Any other questions from council?
Make a motion to
We have,
accept.
okay, I think we have a motion.
We already
We
have
have
a
a
motion.
motion, a second.
Okay.
Discussion, council, please vote.
Motion passes with 5 in favor, 1 against, and 1 abstaining.
Thank you, Tommy. Item 4 is consideration of proposed contract between the City of Jackson, Jackson Community Redevelopment Agency, and Healthy Communities LLC for development of the commercial component of an area referred to as the Central Creek Redevelopment Area located north of the Farmers Market. And I think we have about minimum of 4 people here to discuss that with you. Stan, you can start. We also have the master developers here, and we have Dr. Lake, who chairs the CRA. Go ahead.
Good morning, Mayor and Council. I assume it's still morning. I do have the experts here, and I have representatives from Healthy Community LLC, which is our master development partner here, and I'll ask Hal Crocker, who is a partner in that group, to come at this time. Mr. Henry Turley is also here. If he wants to come to the front, he can make comment if he so desires. And also Laura Cobb is here with our City Attorney's Office, who has been working with us on this contract. This is a fulfillment of a process that we've been going through since almost a year ago when we selected our master development partner. We attempted to draw up a contract that was all-inclusive and had everything that we could ever possibly think of that might be involved in redevelopment, and that became very complex and very unrealistic in terms of projects and scope, because projects are different. Each component of this redevelopment effort is different. And so when you talk about the role of the master development partner, it changes depending on what activity they're involved with, whether it be the commercial component is what you have today, which is the 17 acres just north of the farmer's market. That's what this contract involves. Or if you're talking about the Lambeth properties and the management and rehabbing that's involved with those, or if you're talking about the neighborhood stabilization project or the preliminary grading and reworking of the old street department property, or whatever you're talking about, the project changes. So that's why we decided to deal with each component separately, and so you will see subsequent contracts that will come to you that will deal with each component of the project and deal with just the scope that involved in those activities and those services. So at this time, I'll open it up and let you ask questions, but again, direct your questions at Hal, because he has all the answers, and Laura, she has everything else that has to do with the contract, so I'll give it over to them.
Okay, any questions from council as to the contents of this contract?
Just very, very quickly, so this only deals with the 17 acres?
That's correct.
The only deals with the 17-acre site?
Any other questions from council? Councilman Wallace?
Just give us a total overview of the whole project from start to finish, and, you know, where the money comes from, you know, where it goes, how y'all get paid, just a kind of general overview, if you don't mind.
Sure. Well, everybody's familiar with the area over there. It's 17 acres that surrounded the old city garage that's torn down. Previously, it went out for request proposals, I guess 5 or 6 years ago, and nothing came from that. We took a new look at it when Mr. Turley and I became involved and decided that we wanted to, you know, ask for this opportunity to redevelop the site. We proposed a lot of tentative stuff to the CRA to consider.
in our preliminary planning. But you must understand, at this point in time, we don't have a contract. We're limited on what we can offer, and part of the reason for asking to go to a contract at this point is so that we, in good faith, can deal with other interested parties, investors, and financial institutions to try and work together our half. Essentially, we've suggested an enhancement to the existing Central Creek, which looks like a ditch over there now. Some public areas that would be developed there that would enhance the setting. We've looked at some infrastructure improvements for the streets surrounding the 17 acres. Then look for some opportunities for the right kind of development that would happen inside there. Now, in our document, we have suggested some different projects that we would work toward and determine the feasibility of, and if are feasible to go forward with. We mentioned some multifamily, which would be some market rate apartment units in there. We talked about some area that would be reserved for business / commercial retail development that would be done on a certain portion of the site. But mostly inside the document, it allows a framework allowed us the ability to work on the project and to develop it to the fullest potential with the support of the CRA. So at the end of the day, whatever our ideas are, we'll have to present a final development plan to the CRA and planning, make sure that it's consistent with the goals of the CRA and make sure that it's feasible. We've discussed how some of that financing will be arranged. Essentially, most of the monies that would be invested in the site itself, as far as the buildings, commercial buildings, and the multi-residential buildings, and some of the potential future home sites, would all be funded with private dollars. The partnership involves some infrastructure improvements that we're asking to be funded in order to, show good faith by the CRA or city in setting an environment where we have the best chance to be successful.
Okay, the city owns the property currently.
That's
We're gonna deed it over to CRA. Now, the city.
Well, it could, I think that's the process we're talking through now. It could either remain in the city's lease, but I think the plan is to have the CRA lease it.
Okay, so say I wanna come in and build a apartment complex. Right, I come in and I'm gonna lease the property for the next 50 years or 30 years or however. And then I'll build my apartment complex there. The city's funds are gonna be used to build the infrastructure, the streets and the curbs and sidewalks,
Yes, sir.
those types of things. All right, and then our partner in the deal is gonna be paid by part of the rent that comes off those properties that are built, or that's the
Well,
piece I'm.
we would actually, participate in the ownership of the property. So we would get paid by, what's doing this. Any developer would having a successful project.
Okay, so if I was the builder and came in and wanted to build it, then you would be a 10% owner in my company, or that.
We
rental
would
unit,
work
whatever.
those issues out and work financing out for the portions that would
And
be
there's
private.
guidelines in here for what.
There's some guidelines. Most of the guidelines that, several questions have been directed to me informally about, how we get paid and why, and if we're doing this all with private funds, why would we even have to disclose how we would get paid? And the reason is because we are asking for the city to participate in some of the infrastructure improvements around the site and the ongoing neighborhood stabilization effort, that will enhance the opportunity, the chances for this to be successful. And also because of the land lease, would be, some preferred components to the land lease that would try and make it more attractive to us and how we would obtain our financing. So for those reasons, we just wanted to do full disclosure about how we're doing this, that we wanted to know that we weren't unjustly enriching ourselves beyond the norms of what a developer would ordinarily get out of a project when they finance it, so that, since the lease to some extent is second or third in line on some of the payments, we just wanted to make sure that we were open and transparent in the way that we did business.
Okay.
But none of the funds, most of the funds for any compensation to the developer come from projects specific to this, except for some
And then
management fees.
the funds the city would be using to build the streets and gutters are gonna come from the real estate taxes that'll come off of those properties? Or out of the TIF district?
Well, you know, of course, TIF funds, as they start to come in, can be used for those improvements or incentives or whatever helps the redevelopment effort. Initially, there will be a capital outlay for the infrastructure, and we're talking about a method of funding that now.
I think next month, council will receive a recommendation to, again, use an existing 108 loan from HUD, which we talked about several times in a previous project, with total proceeds from that loan being roughly $3 million, 1.5 for this district, 1.5 for District 2. That way, the payments on that $3 million would come from our existing CDGB allocation, which we get once a year from HUD. And really, as far as local tax dollars, we may elect to put some more in, but initially, in order to give enough credibility to the first phase of funding both these, we feel like probably right now, considering the financial condition of the city and other cities, that we may be best served by applying for that 108 loan through HUD. And council will get that next month, probably.
Will these pieces of property be part of the area that they do not pay real estate taxes on, or will they pay real estate taxes?
Well, it's possible. Again, that's something that we'll work through as we move. It depends on the project, as it often does. You know, I assume in some of these projects there'll be incentives that will be necessary to bring the project on, because we're talking about a very limited investment on the part of the city or the CRA. But a substantial investment on the private side. So to leverage those dollars, there may be a pilot requested, but again, that will be for a specific period of time. And after that time, then it rolls on to the tax rolls and rolls on with the improvements. And of course, the TIF would then pick up the exchange.
Will the improvement of the pilot request, does that come before us, or is that just the CRA?
That goes to the Revenue Finance Corporation, who establishes that and oversees that. That's an existing agency.
Question? I'm done. Yeah, thank you very much.
Councilman Newdecker, go ahead.
Because this is a rather long document. We're not going to get into all of this. There is one question I had in regards to the relationship between the Redevelopment Corporation and Jackson Housing Authority, and how that partnership will work financially as well as productively.
An excellent question. The Jackson Housing Authority, as is their mission, along with community development, which they handle out of that same office, has a mission to do improvements to the community, particularly targeting low to moderate income housing and improving the neighborhoods where people in that economic strata live. They've applied for several grants to work on improvement of housing and neighborhoods over the last year and a half. Some of them are in a position to be implemented now. In particular, we've talked a lot about it, and I think it's come up that they have a grant for Neighborhood Stabilization 1, in which we have a contract, Healthy City LLC, to act as their developer on that project. And this particular grant and some of the others out there were specifically designed to work with a master developer to help implement it. And I guess that's the biggest difference between the ongoing work that they're doing on Phillips Street right now and what we would be doing. We would be acting as a developer to help put together a plan and implement it that would enhance the neighborhoods over there and turn them around. So how does I guess by being selected as the master developer, it's empowered them to negotiate with us and accept whatever fee is built into those grants for the development portion.
But it'll be different in terms of, on the Phillips Street, they were limited to 80% of median, which made it a little bit difficult because the pool was smaller. In the area that we're looking at, we're talking about 120% of median, which is a family income of in the low 60s, 62,000. So it broadens your spectrum of
that is a maximum income. Certainly, we'd still like to serve all spectrum of it.
I guess my question is the area is that we're talking about in this contractual agreement is the 17 acres. is that agreement with the housing authority within that 17 acres or outside that 17 acres?
It's adjacent.
Adjacent to. So we're talking about an area either on Dedrick or
On
Johnson,
around Morgan, Wells
Morgan,
Alley,
Hatton,
Wells
and so
Street,
on.
those, because.
Wells Alley and McCallett, Johnson Street, you know, on over there.
'Cause we're
But-
trying to-
But not necessarily limited to that, but that's a target area that's important to us, obviously, because it would help, it would help improve the area, it would help lay the groundwork for success in our development.
And we're trying to create a critical mass, because by the nature of projects going on adjacent to each other, you're getting the benefit of things changing and the environment changing, so that someone that's investing in a single-family home can see that they're investing in an area that's gonna be improved also.
Well, it's not my district, it's almost a deal breaker for me.
Yeah. We'll head your way.
Yeah, I know you will. Take care.
Mayor, if I may?
Yes, go ahead, Councilman, sorry.
With respect to the multifamily housing and the commercial development, will those projects come back before planning and then to us, or through the CRA and the
They'll have to go through the normal rezoning requirements if there's rezoning that's necessary. You know, but of course, in terms of the projects and what the master developer carries out on behalf of the CRA, they will review those projects as long as they're in compliance with the plan. They'll see that and approve those. But anything that involves zoning, anything that requires a development review by a body, say the Planning Commission, where they review anything in terms of design in a redevelopment area, unless it's historic in an area, and then the Historic Zoning Commission does. Those normal processes will still be in place.
Thank you.
Question, Mayor?
Go ahead.
Just real quickly, getting back to neighborhood stabilization, I thought it was the intent of the CRA not just to revitalize areas, but also to provide homeowner occupancy.
Yes.
And yet we're proposing the very first project out of the gate is a basically it's apartments is what it's gonna be. And Dr. Lake could correct me, but my understanding is anytime you have an apartment area within 5-10 years, that area degenerates and you have the same problem that you started out with. Is that?
I don't think that's true. I mean, we have some examples around town where some projects that are 40 years old, you know, have degenerated and become part of a neighborhood that is on the downhill slide. But we also have other projects that are where we have some apartments that are 30 years old that are still well maintained and an asset in the particular area that they're in. Oaks would be a good example of that. You know, I think they're 38 years old. So I guess part of that really depends, you know, and some things in planning your development have a lot to do with what area do you choose, what are the sustainability issues in the neighborhood, and some of it just have the fact that some of the paradigm of what makes sense today in modern urban living and what made sense 50 years ago, you know, have changed. We believe that this is a good component to the overall stabilization of this particular area and an enhancement to the downtown area. Because over the years, I've been involved in Jackson downtown, you know, issues for a long time, and one of the big missing components that we've always had in enhancing the commercial development of the downtown area has been that we don't have enough people living in the area. Over the years, you know, we've had that transition, you know, demographics change, people move around, so everybody's always saying, well, why don't we have more restaurants downtown? Why don't we have more people living downtown? The deal is what you need a big splash that brings both of them at the same time. Our incremental changes in development haven't really worked. But in addressing one part of your question, the particular advantage of the land lease in this particular circumstance over and above us actually owning that portion of the property outright is we can have some covenants in the land lease for the city to have some enforceable covenants of the upkeep and the care of the property that would make a difference. Yes. Where in a lot of other kind of developments you wouldn't have that.
Do we have those covenants in place, Mr. Pilot?
They will be a part of the lease, yes.
Just real quick, what is the percentage of rental property in Jackson and how much of that is occupied?
Well,
residential.
I don't have that figure off the top of my head. I can tell you that we do apartment surveys of apartment units throughout Jackson. The occupancy levels stay relatively high every year. So I wouldn't say that we're overbuilt. I can also say that in an urban environment that density is important and is a trend that is moving in terms of people's wanting to be close to their work and amenities and things, and density is how you accomplish that. Now, also keep in mind that this is only one small component of a large area, and we're not looking at multifamily throughout the whole district. We're looking at opportunities for multifamily where it makes sense. We're also looking at ways to keep the management and the maintenance up. And I can also say, if you want, Mr. Turley can tell you that as a part of Harbortown, they had an apartment development that was a part of that, and it has been a good addition and have been a good neighbor and been a part of that development. So it's just a component. It's not, we're not looking at multifamily as the only residential we're going to do. In fact, the NSP project that Hal is a part of, or Healthy Communities is a part of, is the single family component of this, is its first phase. So it's commercial, it's multifamily, it's single family. It's trying to create a broad spectrum so that when we go out to market to try to look for people to fill in these slots, we have a broad product to offer instead of just one thing that might only appeal to one person.
Last question. Page 24 of the contract, reimbursable expenses. We are reimbursing expenses at 105%.
Yes, and there was much discussion about that, and I can explain it, and it started out at 110%, and we had much difficulty with that, and Vicki had I can say your chairman of your CRA really was a champion of trying to deal with that, and what that is the developer at times will have expenses that he'll have to be carrying, and the 5% is to allow him to carry those expenses. He's having to put forth his capital, he's trying to put forth his dollars, and he's carrying that for a time until he gets reimbursed. And I'll also assure you that that in the contract, all reimbursable expenses have to be approved prior. So this is not something where they can go out and run up a big tab and then say, now you owe us 105%. They have to be approved, and then the 5% is to cover the carrying of those expenses until they get reimbursed. And that's normal market policy, from what I understand.
And it's approval based on a pre-construction and marketing budget that's given to the CRA, and they're the ones that are going to.
That's correct. That's correct.
Question.
Go ahead, Councilman.
Yeah, would you agree or not agree that the majority of the project that we're talking about, all the different types of homes that or residential properties that we're talking about, the majority of those are subsidized?
Subsidized in what way?
They have some sort of federal subsidization.
I can't speak as a whole because again,
50% or greater, or 100% or less, or 90%?
Well, the NSP program in particular, and understand, while it's not actually a part of this document, it is a component, because we try to look at the redevelopment area as comprehensive. The NSP program is designed to have some incentives that are federally provided, and you can call them subsidized instead, that would help people be convinced that it is a good investment to come to this part of town and try this out and take some risk, as opposed to building a house over in a newer part of town, in a fresher part of town.
How much?
So there are some incentives. In the NSP 1 program in particular, there's an allowance for a $15,000 incentive per house. Yeah.
My question again is, what percentage of these properties that we're developing will be part of these types of programs?
Well, if for the portion that would be funded by the NSP, I guess all of those. For the ones that would be privately funded, and in our preliminary drawings, of course, some of this is subject, does it work or does it not? We're subject to the market forces. We have plans to build some unsubsidized homes in here in the second phase, depending on how successful we are. And that's all I can say.
20% then would be unsubsidized, would you say?
I really couldn't speak to a percentage. The NSP program is designed by its nature to have some incentives based on qualifying buyers at 120% of ordinary income or less. We believe that if we enhance the neighborhood and we have nicer houses, that at one point that will lay the groundwork for people to come in and houses that are not. That's what we believe.
So that originally, the first 100% are going to be subsidized.
That's right. First ones.
Which is the time period in which you're facing the most risk. So, I mean, that's why you have the incentive, is because once it becomes a no-brainer, then the risk is diminished. But when you're going in there and you're pioneering, that's when you expecting the most risk. So that's the reason for the incentives.
Councilman Wallace.
My project map looks like this. Could you get me an actual map? Just email me one or something?
Sure.
The other question I had is go back to the fees reimbursement or whatever. On that page 24, where it's got the developer fee for the multifamily house, the commercial, 6%, is that CRA paying that, or is that coming from the developers?
That would come through the project. But what item is that?
Just A, B, and C.
Okay.
501 subsection B.
Well, we try and put something in to cover circumstances, whether or not, the choice is on a reimbursable expense. If the CRA has their, has some kind of a organization set up, a director, bank account, and we have to pay a $10,000 bill that's really their bill and not our bill, then they can pay it direct. They don't have to pay 105%. But if for expediency, I have to go buy some stamps, to mail out a document that it's really a CRA expense, and I ask for reimbursement for handling that for a month, I'm charged 5%.
I understand the reimbursement expenses. I'm talking about the asset management fee and the developer fee for the commercial.
That would come out of the project itself. That would be,
CRA funds then?
assuming that we have a tenant, we're managing a property, that's where it comes from.
Okay, y'all confused. When you say project, you mean who?
Let's suppose we build a strip center. We have a tenant. We
Okay.
manage the property. We manage the building. We collect the rent.
So that comes
we
out of the
pay.
tenant funds, basically?
Yeah.
Okay, that was my question. Okay.
Okay. Any other questions from council? Is there a motion for approval?
Make those motions.
Okay, we have a motion. Second, any discussion? Council, please vote.
Motion passes 6 in favor, 1 against, and 1 abstaining.
Thank you, Mayor and Council.
Thank you all. Thank you.
Thank you.
Number 5 on new business, consideration of acceptance of streets in Palmer Wood, sections 1 and 3, Brookwood Drive, Cedar Crest Cove, Ironwood Cove, and a portion of Palmer Drive as depicted on your map in your packet.
Move the approval.
We have a motion for approval. Second, and discussion. Please vote.
And the vote is unanimous.
Item 6 is consideration of budget amendments. Ms. Bell?
Review. The first budget amendment that we have is for the EDI grant. It's budgeted on the expense side, but not on the revenue side, in the amount of $173,967. The amendment will actually put it on the books to get it on both sides, and so the expense, we will budget in the unanticipated expense, and of course, the revenue of $173,967. This will keep our budget in balance. The second one, do you want to vote on?
Yeah, let's go ahead and take both individually. Any questions on that amendment? Is there a motion for approval?
This is the anticipated expenses. So moved.
I have a motion. Do a second.
Second.
Discussion. Council, please vote.
And the vote is unanimous.
The second amendment that we have is for the Community Redevelopment Fund. We have professional services of $110,866.15 budgeted for FY10, with offsetting revenues to come from the rental revenue and the transfer from fund balance. The rental revenue at $8,000 and the transfer from fund balance of $102,866.15.
Move the approval.
Approval. Second. Discussion. Council, please vote.
And the vote is unanimous.
The third amendment that we have is the parking garage. This has already been taken care of, but to get it on the books, we have an amendment in the amount of $835,000 to be put into the capital fund. The revenue side will actually be a transfer from debt service, which the transfer was already made when the auditors approved the excess funds. So this will only increase the budget by $835, so.
Excuse me.
Yes.
Go ahead.
Last meeting, we approved 824, or was it the 835?
Yes, 824 was the purchase price, and then $2,700, I believe, Susan, for the fence. And then Scott is putting some markers in there, so it may be less than that, but I just added another 10,000.
Question.
Thank you.
Question. Are we through making improvements to the property, or is
We are until spring,
so all the property
consideration of paving at that time, and it's really in violation of our own codes to leave it gravel. So we're gonna have to pave it with landscaping, I may add,
all the property been filled?
as much as we're gonna fill right now, rather than face potential litigation. If build a retaining wall and fill the rest of it, but that's not at this point. Okay, we have, on that final amendment.
Make a motion to accept.
Okay, we have a motion to accept. Do I have a second?
Yeah, I'll second.
Have a second. Discussion. Council, please vote.
Motion passes 7 in favor, 1 against.
The fourth amendment that we have is the fire department is receiving reimbursement funds from emergency management to cover USAR training, rescue training needed by the department. The reimbursement will be in the amount of approximately $53,000 for fiscal year 10, and this will come from EMA.
Move for the
emergency
approval.
management.
Okay, we have a motion for approval. Second. Any discussion? Council, please vote.
Motion passes 7 in favor, 1 against.
Thank you.
Thank you, Karen. Councilmember, before we get to the final item, let me just recognize a young man who has sat here for about 2 hours and a half, learning all he can about the function of local government, and whose attention span far exceeded some of the adults that are here during this meeting, and his name is Alec Dumit. Alec, would you stand up and let the council recognize you and thank you for being here? Okay, item 7, consideration of invoices over $10,000.
So moved.
Second.
Have a motion made, second,
Question?
discussion?
Yes,
One question. Go ahead.
Arcadius, are we complete with this particular project? Will those costs be added to this particular project, which is we were talking about the 17 acres, I'm assuming, yeah. And the gas?
That may take 30.
Okay. Thank you, sir.
Council, please vote.
Motion passes 7 in favor, 1 against.
There being no further business, meeting is adjourned.